Hello, my name is Chris Sweeney. You probably remember working with me through Acro Construction or through a staffing company that provided construction labor for Acro Construction. I wore my old work shirt to refresh your recollection of me and the work you may have done with me. If you're receiving this video personally prior to July 1st, 2026, it is because I've already talked with you about being a witness or you are a victim of a wage fraud scheme. If you're receiving this after July 1st, 2026, it is because I am seeking witness statements on behalf of people defrauded of wages, or I missed sending it to you prior to July 1st, 2026, as a person that was owed wages. I have used the July 1st, 2026 date because shortly thereafter I plan to make a public release of information depending on several factors that occur prior to July 1st. Because there's about 200 people who were defrauded out of wages, I have set up a unique email address where you can email me, which is acrolaborfraud@gmail.com. Former Acro construction workers, temps, laborers, helpers, and other employees and staffing company employees have information about unpaid wages, misclassified work, falsified certified payrolls, and labor kickback schemes on federal construction and service projects. Different federal projects may use different wage rules, but the basic issue is whether workers were classified and paid correctly for the work performed. Certified payroll is the paperwork a contractor submits on many federal projects showing who worked, what classification they were listed under, how many hours they worked, and what wage rate they were paid. The main point is simple. If you worked on a federal project and were paid as a laborer, helper, temp worker, or lower paying classification while you were actually using tools, doing skilled trade work, doing electrical, mechanical, sheet metal, insulation, HVAC, demolition, or other craft level work, you were likely underpaid. You were purposefully misclassified on certified payrolls, which were fraudulently submitted on federal projects, where Acro later falsely claimed you were paid proper wages for the category of work performed and knowingly submitted false claims for payment of government funds. That matters because on federal projects, contractors are required to pay workers the correct prevailing wage for classification of the actual work performed. The laborer or other lower paying misclassified title given on the certified payroll does not control. What actually matters is what craft work you actually performed. If you were called a laborer but were doing apprentice level or journeyman level work, using tools, installing materials, performing skilled trades, or performing craft duties, then there is a wage misclassification issue. A laborer typically moves materials from point A to point B, hands tools to a worker, and keeps the job site clean. If you performed work of a craft classification to demo or install and were improperly classified as a laborer, then what does this mean for wages you should have earned? Each federal project has a wage determination. Let's say sheet metal mechanics have to be paid $50 an hour, and you were installing ductwork and were classified as a laborer at $20 an hour. Then you are owed unpaid wages of $30 an hour. And over the course of an entire 40-hour work week, your gross earnings should have been $2,000 instead of $800. The exact rate depends on the project wage determination. The wage determination be thought of as the minimum wage for the work performed. In essence, the misclassification of lower paying wage rates is akin to not paying the minimum wage. If you were told you were in a probationary period or treated as a laborer for the first 90 days while using tools of class classification, being called probationary does not automatically allow Acro to pay laborer wages if you were doing skilled craft work. That standard only applies if you were registered in an apprenticeship program, and Acro Construction does not have an apprenticeship program. In fact, to not apply the strict standards of the contract or the Department of Labor's regulations, Davis-Bacon or related act, executive orders, or variations related to the contract requires the company to request a variance from the Department of Labor, where such waiver or exemption must be documented. To my knowledge, Acro has never received a variance, and if so, has failed to provide it. They simply lie to the Department of Labor, saying these violations do not exist, which is more of the reason why your witness statement is critically important. If you were not paid for travel, overtime, per diem, fringe benefits, sick leave, or paid for all hours worked, that may also be important. I mentioned not being paid for all hours worked because since trying to collect evidence of these frauds, I have discovered that hours were removed from submitted timesheets to what appears on paychecks. This is especially true when working overtime. On numerous occasions, hours were removed and cannot be dismissed as an accident in calculation because I have yet to find where hours were added by accident. I also know that when we hired through a staffing company and Acro was billed for hours worked by the staffing company separately, where the employee had to verify the hours, not a single paycheck was undercut on hours. This is important because it shows willfulness. This fraud includes my own hours, which were undercut, which I did not know were undercut until confirming this recently through my bank records. This is why I'm asking you to compare your own time records, pay stubs, bank deposits, and certified payroll information if available. Every person with these records so far has shown hours moved to pay less, hours removed, or misclassification, the only exception being where a staffing company had the hours submitted independently for billing purposes. I am asking people who have knowledge of these issues to write truthful witness statements for the benefit of the Department of Labor and the contracting officers of the contracting government agency or for the Office of the Inspector General. This is another reason why I've set up a unique email address, acrolaborfraud@gmail.com, spelled ACROLABORFRAUD @gmail.com, because there are over 200 victims of this wage fraud spanning more than 20 federal contracts that I know of. Once you respond to the email, I would like to interview you concerning the work you did or you witnessed other people do according to the scope of the work of the project, which is the easiest path to prove you are entitled to wages for the craft work you performed. I am asking that people contact me by email only. I want this process to be organized, documented, and easy to provide to the proper government agencies. If you contact me, I can send you an affidavit form, a release form for the Department of Labor, and a checklist of information that may help determine proper unpaid wages. I could also provide the complaint form for filing your own complaint with the Department of Labor. I strongly encourage every worker to consult with an attorney about their own rights. People should make their own decision, and many attorneys offer free consultations. Because an attorney can file for civil racketeering actions or False Claims Act actions for each and every project. It is possible to find an attorney willing to pursue a class action, as many people have knowledge of this wage fraud. Part of the scheme by Acro Construction was to go to higher wage states than the state of Florida, where Acro was based out of, and take advantage of the higher paying wage structures of the state, and state laws may provide greater protections than that of the state of Florida, which does not have its own agency to report unpaid wages to. When a person works in two states, the worker gets the protections provided by both states. Workers may have rights in the laws of the state where they perform work, and some states provide stronger remedies than Florida, where Acro is headquartered out of. Additionally, other states may have treble damages and allow interest from dates of those unpaid wages. I am not a lawyer, and this video is not legal advice. My goal is to help witnesses and victims understand the issues, preserve information, and make it easier to report the facts to the Department of Labor and other appropriate agencies. I strongly recommend you report the wages you are owed to the Department of Labor and your state labor agency. I remain open to discuss everything directly with an attorney you may hire, any labor department investigator, or any office of inspector general's attorneys that may look to speak with me about these issues. This wage fraud included myself when I first worked for Acro Construction through a company where I was misclassified as a laborer starting in 2014, even though I was performing as a pipe fitter for many hours on the projects I was working on. This is a willful scheme that has been going on for decades because the certified payrolls are deliberately misrepresented, involving the same primary actors of the fraud dating back over a decade, and what attorneys and investigators may view as a civil racketeering pattern. I also want workers to understand that this may involve more than ordinary wage disputes. I hired an attorney to help navigate the course of actions in this matter. Acro refused to produce any records. To this day, they have refused to produce paycheck stubs I did not receive. They have purposely omitted and hidden public information on certified payroll documentation, and they use their attorneys to make false statements they know are false. The evidence will show a civil racketeering type pattern involving misclassification of workers, false payroll reporting, unpaid wages, unpaid overtime, unpaid travel or training time, improper use of laborers for trade work, and knowing false statements for payments connected to federal contracts. In plain English, the litmus test is that workers were underpaid while the government was billed as though the contractor was following the law. That is where the False Claims Act may become relevant. The False Claims Act is a federal law where most states have corresponding state laws that allow the government and private whistleblowers to pursue claims where false or fraudulent claims for payment were submitted to the government. These are called qui tam whistleblower lawsuits. If a contractor submitted certified payrolls, invoices, payment applications, change orders, or other documents that falsely represented compliance with wage laws or contract requirements, that creates a False Claims Act issue. The statute of limitations for these False Claims Act cases have a maximum 10-year statute of limitations. I mention this because this is a complex and drawn-out situation. In pursuing these matters, I have attempted to discuss this with the attorneys who were hired through Acro's bonding company about these qui tam whistleblower issues, and the attorneys have refused to discuss them. Qui tam suits cannot be brought by an individual, but require an attorney. The collection of witness statements now is what actually of what actually occurred or happened will help attorneys distinguish the facts and streamline the process. While I individually collect statements over the next few months, I also mention this because the process will likely take a few years until settlement is reached, and the collection of evidence, where each project requires a detailed accounting of events, secures the recovery of unpaid wages through the False Claims Act process. Additionally, if you are receiving this and you did not work with me, but the same instances occurred where Lorenzo Alvarez or Alan Cooper were directly operating this labor fraud scheme, it is because they were the directors of the scheme directly with you. Then, Billy Tolson and the payroll person, Tamara Lamb, actually coordinated the fraud from the corporate office. It should be noted that Alan and Lorenzo profit share with Acro Construction and have their own businesses where they use those businesses to defraud the IRS instead of an accurate accounting of income taxes owed. Alan and Lorenzo profit off of this scheme, and Alan Cooper receives a 50% profit share from Acro, which in part, Acro was funded by a money laundering scheme after Alan defaulted on the bonds on a handful of federal projects when he owed the IRS over $2 million. I am in the process of reporting this to every contracting agency I have knowledge of the fraud to. Another example of the fraud I have caught Acro Construction perpetuating is moving hours from a higher paying federal project to a lower paying federal project in the same work week. So, a hypothetical example is if you were a person who worked 25 hours on a week project that paid $25 an hour and another project that paid $20 an hour were for 15 hours during the same work week, they would take hours from the timesheets submitted from the higher paying work week and move them to the lower paying project. It is significant to note the Department of Labor has not yet reviewed the timesheets to the certified payroll. Their process is look at certified payroll and ask the corporate offices and the project managers questions only. This is why your witness statements are critically important. The Department of Labor process does not involve the victims of the unpaid wage fraud. They are lied to by the corporate office and the project managers with no recourse to substantiate unpaid wage claims unless you provide the information where they can investigate. So, the accounting of what you did and the aspect of the crass classification you were performing in is where prior investigations of businesses operated by Alan and Billy dating back over 20 years, where they know the investigation process and simply know operating the fraud in the field and through the timesheets are stuff investigators simply do not look at. When caught before, Alan and Billy simply close the business and open a new business. They know the process of the investigations and have cultivated a path to commit the fraud. It is a racketeering scheme where the victims are left voiceless unless someone knows the depths of the process to procure a just result. Once again, I need to clarify. The attorneys were hired through the bonding company to create silence. The records, including timesheets, will show the operation of the frauds on a continuous pattern spanning numerous projects, hundreds of victims, and millions of dollars of fraudulently tamed funds through their knowing false certifications of payment to the federal government. The moving hours during the same work week from higher paying to lower paying projects, I have found this to have occurred on 4 federal projects so far. But seems they know the contracting officers only look at the certified payrolls. So even though the contracting officer has no way of knowing this fraudulent activity, Acro is conducting this fraudulent activity between the owners, project managers, and payroll staff. I am also concerned about statements and conduct by Acro Construction's attorney in prior litigation and communications. I believe there are serious issues involving what they know, what was disclosed, conflicts of interest, and whether false or misleading positions were taken. Those issues should be reviewed carefully by attorneys and the proper authorities. In addition to reporting the fraud on wages, I am also reporting the other instances where the government was defrauded, and this includes Acro Construction's attorneys who refused to discuss and settle these wage fraud issues, which I have blew the whistle on already to the Department of Labor, where the attorneys are part and parcel to the actual frauds and directs Acro Construction to hide information relevant to unpaid wages. I have provided the attorneys with phone recordings I was directed to make in prior litigation, where they have signed documents under oath and refused to provide it as proof of wage violations. The attorneys are actively engaged in this wage fraud, are witnesses to it, and refuse to confer on the conflicts of interest. They are hiding on purpose the evidence needed to just pay people what they are owed. Again, I am asking for truthful witness statements. I am not asking anyone to exaggerate or attack anyone personally. I am asking people to tell the truth about what happened, what work they were performed, how they were paid, and what they were told. If you believe you were underpaid, misclassified, or used as a laborer while doing skilled trade work, please write down what happened while you still remember the details. Most important is the tools you used and what you demoed or installed. I am reaching out to the labor unions where these frauds occurred for guidance and interpretation. They have been instrumental in helping define what work falls under the proper craft classification of the union's purpose. Because Agro targets higher wage areas to undercut wages through fraud, the union based contractors who follow the law lose contracts, and it prevents properly classified apprentices and journeymen from earning their fair share of wages from the federal government's allocations for funding. The Department of Labor is currently reviewing some items, and I'm awaiting their decision on my initial reporting of these unpaid wages scheme for everyone, including myself, and I am in a time crunch to get information to them concerning an active complaint on behalf of Cynthia Stratton, who worked on multiple projects where she was misclassified as a laborer, even though performing as an HVAC mechanic. pipe fitter, sheet metal mechanic, insulator, among other craft work she performed. This is an active Department of Labor matter. Cindy's situation is the immediate focus. Statements may need to be gathered quickly. Even short statements can help. The instances involving her bring attention to several unique projects where witness statements can be viewed to make efforts of the Department of Labor and the contracting government entity easier. So I ask everyone to email me at acrolaborfraud@gmail.com so we can expedite the gathering of information so the government can understand it easily. If you worked with Cindy Stratton, knew of her travel, training, classification, or treatment, or have knowledge of work performed by her, your statement may be very important for everyone, and the sooner we can get that together, the sooner we can break through the gatekeeping and scapegoating and gatekeeping by the attorneys Acro has hired. I may also be able to help workers organize demand letters, collect documents, understand what information attorneys or government agencies will likely need. I prefer to do this in a manner that becomes a verifiable record. So please email me to start the process. A demand letter is a written request for unpaid wages based on the project's dates, classification, and work performed. I intend to write a witness statement myself for everyone on each project, so you have a written record you can take to an attorney or provide to your state or U.S. Department of Labor for the individual recovery of unpaid wages. Please contact me by email so there is a written record. When you email, please include your name, the project you worked on, the time you worked on the project, your job title or pay classification, and a brief summary of what you recall. The purpose of this is simple. Workers should be paid what they are legally owed. The Department of Labor should receive truthful information, and federal agencies should know whether contractors submitted false payrolls or submitted knowing for the false claims for payment. I started a YouTube channel so everyone can view and subscribe to the YouTube page. I have tried to collect for everyone in a manner that privately would have reimbursed everyone for their correct unpaid wages. Unfortunately, handling this in a private manner is no longer an option, especially when the attorneys for Acro are active witnesses to unpaid wages and refuse to discuss the matters. If you know something, now is the time to write it down. A useful statement should explain in your own words your name and contact information, when you work for Acro Construction or related companies, which projects you worked on, what classification you were paid under, what work you actually perform, whether you use tools and what you demoed or installed with those tools, whether you perform trade work, whether you were paid travel, training time, overtime, per diem, or fringe benefits. Whether anyone told you how your time or classification would be reported, whether you saw others workers being misclassified, whether you have pay stubs, time records, text messages, emails, photographs, or other records and documents. Please do not exaggerate anything. Do not guess. Do not write what someone else told you unless you clearly explain who said it and when. The most important thing is truth, and I am here to help. Thank you very much, Chris Sweeney.